I'm Bonnie Urbay. Welcome to the Contrary, a discussion of news and social trends from diverse perspectives. This week in our Women Thought Leader series, we have Linda Greenhouse. She covered the Supreme Court for the New York Times for 3 decades and is now a columnist for the Times and a teacher at the Yale Law School. Her new book, Justice on the Brink, looks at how the High Court has changed in just 12 months, and especially the transition from Ruth Bader Ginsburg to Amy Coney Barrett. So, Linda, let's start with, you give quite a bit of background about these women and how they came to the High Court. Please give me a couple minutes on each of them, and particularly the parts of their background that you think drives or drove their passion for law from a conservative view and a progressive view.
Sure. First, let me say I'm happy to be back on the show. It's been a couple of years, and you and I go back a long way to this press corps decades ago. So thanks for having me back.
And very good to see you too.
So Ruth Ginsburg, as people know, began her career really as an advocate for women's rights during the 1970s, where surprisingly the Supreme Court had never yet gotten around to even recognizing sex discrimination as a constitutional harm. Didn't think the Constitution said anything about the equality of the sexes. She began her litigation campaign on behalf of the ACLU and was very successful, really put herself on the map. She was known in many quarters as the Thurgood Marshall of the women's rights movement. Jimmy Carter named her to the Federal Appeals Court in DC, and Bill Clinton made her his first Supreme Court nominee. So that was her story. Amy Barrett, much younger, she's currently 48 years old, has spent her career sort of in the sheltering arms of the conservative legal movement, which identified her as, I gather, quite a brilliant law student at Notre Dame University, where she went to undergraduate school as well as law school, propelled her to a clerkship with Justice Antonin Scalia, who became her mentor. And she was during her teaching career, she taught for a long time at Notre Dame. She was a favored speaker of the Federalist Society. She went around the country giving talks. And it was sort of a natural progression that President Trump, in the opening months of his term in 2017, named her to a seat on the Federal Appeals Court in the Midwest, the Seventh Circuit, that the Republicans had blocked President Obama from filling. There was a vacancy there. And the night that Ruth Ginsburg died, September 18th, a year ago, Mitch McConnell, the Republican Senate leader who had so carefully engineered keeping the Scalia vacancy open so that Trump was able to fill it with Neil Gorsuch instead of President Obama being able to fill it with Merrick Garland. McConnell called Donald Trump, who was in the air on Air Force One, flying back to the White House from a campaign event, and said 2 things to him. You will fill the seat, even though, of course, Election Day was just weeks away. You will fill the seat, and you will fill it with Amy Coney Barrett. And so that's where we are. And that's why I titled the prologue of the book, The Chosen One. And of course, the chosen one is Amy Coney Barrett.
You talk at length in the book, and we'll get into this in a little bit, but about how Amy Coney Barrett changed and is changing the view of the court on a lot of issues, such as women's rights. But how would Ruth Bader Ginsburg, do you think, have felt about Donald Trump comparing Amy Coney Barrett to her?
Ruth Ginsburg had a capacious view of history and of human nature. And, I think she certainly didn't want Donald Trump to be the one to fill the vacancy. We know that. She said that. But I think she might have found Amy Barrett somebody who she could talk to and maybe teach and work with. We We haven't seen much from Justice Barrett since she came on the court. It's a very short time. There aren't that many data points. But I have to say, there are a couple data points that tell us that she's not in the pocket of the far right on the court. She's written a few things that I have interpreted as saying to Justice Sam Alito, the leader of that end of the spectrum on the court, I'm not your girl. You and I may have a lot of things in common. We're both conservative judicially and religiously, both religious Catholics, but don't take my vote for granted. So I think she might have given Ruth Ginsburg certainly a challenge, but something to work with.
And we all know the famous friendship between the former Justice Antonin Scalia and Ruth Bader Ginsburg, ideological opposites, yet very close friends, especially in their love of opera, and were quite close when the two of them were on the court together. And Barrett clerked for Scalia. What do you think she learned from him about getting along with justices on the left? Because the court has also been going through the last couple of years that, statements that there are Republican justices and Democratic justices. And of course, Chief Justice Roberts said, no, there aren't, very definitively, but their politics do differ.
Oh, sure. And of course, one thing that I'm sure was a very strange experience for Justice Barrett. So she was confirmed at the end of October 2020. The court was shut down tight. I mean, the justices until this term, until October of this year, held all their oral arguments by telephone, not even by Zoom. They weren't looking at each other, by their home telephones. They met remotely until the late spring of this past spring. So she was working from her home in Indiana and wasn't interacting face-to-face with her new colleagues. And so, whatever sort of acculturation or just sort of FaceTime with other people, she being the newcomer on the block, I guess is taking place now, but it didn't take place then. I mean, I'll say this about Justice Scalia. So yes, he and Ruth Ginsburg famously were friends, but they did not influence each other's votes, shall we say. Scalia remained very much Scalia, and Ruth Ginsburg was very much Ruth Ginsburg. And in his later years, I don't think Scalia did much outreach to the liberal justices. He became pretty insulated. He famously said he had canceled his subscription to the Washington Post because it was too liberal. Now, really, you're living in Washington as one of the most powerful people in the government, and you're not reading the Washington Post. So I took that as an indication that he had lost any interest in trying to influence other people.
Now, in the book, you, and of course many others, have called Ruth Bader Ginsburg a rock star. What do you think gave her rock star status?
So in the last phase of her career, talking 7, 8, 9 years, that's when she became the, quote, notorious RBG. Nobody would have called her that earlier because she really was trying to be a consensus builder. But once Justice Sandra Day O'Connor retired and was replaced by Sam Alito, whose arrival really lurched the court to the right, and once Justice John Paul Stevens retired, it left Ruth Ginsburg as the senior associate justice on the liberal side of the court. She began to use her voice, and it was most often a voice in dissent, but it was powerful and quotable, and didn't make a difference in terms of changing votes. But she was speaking outside the court. She was speaking to Congress in the Lilly Ledbetter sex discrimination case, pay discrimination case. She was speaking to history. And so I think that was the Ruth Ginsburg that, at the end of the day, most people became familiar with.
And all the media coverage of her, of course, too, the documentary, which was released as a feature film, et cetera, contributed as well to her stature as a rock star?
Oh, sure. And I say in the book, I think there was a point at which the culture needed her, needed somebody to call out the drip, drip, drip of the constant increasing conservatism of the Supreme Court. Somebody needed to put down some markers. And those of us on the progressive side of the street who have been dismayed at what we've seen largely from the court, we needed somebody to give voice to that. And I think that helped propel her rock star status.
What was the most important decision she ever issued?
Her most important majority opinion for the court was in the Virginia Military Institute case. So this was a state-sponsored military university that accepted only men. And there was a lot of the federal government, a woman and the federal government, the Clinton administration sued VMI, and Ruth Ginsburg got to write the majority opinion that really sort of raised the bar gave new definition to what constitutes unconstitutional sex discrimination. And I that was of enormous satisfaction to her, in no small measure because she got Chief Justice Rehnquist to come along, which was very surprising because he was not particularly open to anybody's claims of discrimination, let alone to women. But she was persuasive to him.
Do you think Amy Coney Barrett has the potential to become a rock star of the right on the court?
Oh, she already is. I mean, I quote in the book some articles from Christian publications where women are writing, finally, we can look at the Supreme Court and see somebody who looks and thinks like us.
How do you see her ruling on women's rights, equal pay, the right to health care, which a lot of people see particularly as a woman's right, and of course, abortion, either chemical abortion or surgical abortion?
Well, the data point we have on abortion is not very cheering. So as people know, on September 1st, the Supreme Court allowed the Texas vigilante law, SB 8, to go into effect by refusing to grant the stay that the abortion providers in Texas were begging for. It takes the vote of 5 justices to grant a stay. The clinics got 4 votes, Chief Justice Roberts and the 3 liberal justices to his left. Amy Barrett could have given that 5th vote. Brett Kavanaugh could have given that 5th vote. They did not. And so SB 8 took effect, and it's still in effect as we sit here today. So I did not find that a very hopeful sign. On the other issues that you raise, equal pay and sort of women's place in the workplace and that kind of thing, we just don't know. I mean, she's never written on those topics. She has managed to raise 7 children while being fully employed. So let's assume she's got some empathy for and understanding of, women needing a work-life balance that's supported by some kind of legal protection. But we don't know enough to really say.
What do you see the court doing, the reconfigured court with Amy Coney Barrett doing in the Texas case and in the Jackson, Mississippi case?
So the Texas case at this point is really procedural. It's whether the federal courts have jurisdiction to issue an injunction against this law before it takes effect. So before the law, the vigilante lawsuits that the law enables have actually taken place. And so the clinics, the providers, or really pretty much anybody who will be a defendant in these private civil lawsuits will have somebody to sue. So just setting that aside, I mean, it's a procedural thicket. Setting that aside, the Mississippi case is really the money case. So the question there, as people know, is the constitutionality of Mississippi's law that bans abortion starting at 15 weeks of pregnancy. In other words, considerably before the fetus is viable. So fetal viability, which was established as the kind of firewall almost 50 years ago in Roe against Wade itself, that's what's protected the right. That, states can make women do all kinds of things and listen to phony scripts and, stand on their head and crawl to the clinic or whatever. But at the end of the day, before fetal viability, they can terminate the pregnancy as a matter of a constitutional right. If the court's going to breach that firewall, then I think Roe versus Wade is basically gone. So what's Amy Barrett's role in this? Well, Mississippi's appeal, and the state appealed because, of course, the lower court had to strike the law down because it's flagrantly unconstitutional under current law. That petition was filed by the state back in the summer of 2020 when Ruth Ginsburg was still alive. The court took it up in the fall as Justice Barrett was coming onto the court. They went over it again and again and again. My book chronicles this week after week. They took it up in their private closed-door conference, what to do about this case. The court had received many petitions like this of these crazy laws that the lower courts had invalidated. And of course, the Supreme Court never took up any of the state appeals because there was no conflict among the lower courts. All these kinds of laws are flatly unconstitutional. But yet in May, and my May chapter in the book starts with the line, I think it was always about abortion, okay? In May, they decide to hear the case. Now, why would they decide to hear the case? It's because there's a critical mass of them, whether it's 5 votes, 6 votes, we don't know, that wants to change the settled law, that wants to use this case as a vehicle to do what a number of them have wanted to do for a whole long time, which is to take a whack out of the right to abortion. And as I said, my view is once you start breaching that viability firewall, you don't have a whole lot left.
A lot of people have argued that viability is a very fragile concept upon which to lay a constitutional right. And originally it was broken down into 3 trimesters. In the first trimester, the woman and her doctor had complete control or something thereunto akin. And in the middle trimester, it was a mixture of the women's rights and states' rights. And in the third trimester, it was all states' rights. And of course, this was 50 years ago. But do you think that was too fragile a platform upon which to lay a woman's right to choose?
The way the constitutional law is now, we read through the lens of Planned Parenthood against Casey, which was a case in 1992 that reaffirmed the right to abortion, but kind of reconfigured that trimester layout that you just gave. So what is said, what Planned Parenthood against Casey said, and that's remained the current law since 1992, is that before fetal viability, the state does have an interest in protecting unborn life, but it cannot invoke that interest to stop a woman from having an abortion. It can seek to persuade her not to go ahead with it by mandatory counseling, waiting periods, different kinds of obstacles, as long as those obstacles don't present what the court called an undue burden on access to the right. So the viability, baseline, I don't think is fragile. I think it's baked into how we understand this question. And it's really important because, a typical question that a justice will ask a lawyer from the bench during an argument is, okay, counsel, what's your limiting principle? By which the justice means, if we decide the case your way today, what are we committing ourselves to for the case after that and the case after that? Because the court, really doesn't sit to resolve individual disputes. The court's making law. What's your limiting principle? So a very useful limiting principle, an essential one, has been viability. Before viability, the woman has the right. If you get rid of viability and you uphold a 15-week ban, why not a 12-week ban? Why not a 6-week ban, which is the Texas law? Why not a 0-week ban? Some states are trying to prohibit abortion at the moment of fertilization. So that's why it's so troubling that the court agreed to hear this case. And my additional concern is that if they uphold the Mississippi ban in some manner without explicitly saying and we hereby hold that Roe against Wade is overturned, the public won't understand the real dimensions of what has occurred. So it's up to people like you, people like me, informed people that have followed this issue to make clear that people understand the door that the court will be opening to the ultimate erasure of the right to abortion.
If the court does that, what does it say about precedent?
Well, that's a hoop they have to jump through. And, the famous line from Chief Justice Rehnquist was, the rule of stare decisis, which is the Latin term for precedent, is not an inexorable command, meaning we honor it in principle, but we can get around it in practice, right? Basically, if we find that the case was wrongly decided on the wrong constitutional premise, not working. I mean, one thing that Mississippi says in its brief is, oh, look at all the conflict and controversy over Roe against Wade. That's just, it's bedeviling the lower courts, and you really have to get rid of it. Well, it's bedeviling the lower courts because states like Mississippi keep passing flagrantly unconstitutional laws. They keep kind of roiling the waters around the right to abortion. If they just, woke up and accepted settled law, everything would be fine. So, that's the situation that we're in.
You talk a little bit about in the book about the shadow docket. Please explain what that is.
Well, the shadow docket is a kind of, catchy, slightly pejorative word for something that exists in every court, which is an emergency docket when things come up that you can't wait for the ordinary months-long process of granting and hearing a case to play out. And somebody has a plausible claim to immediate relief of some kind, an injunction, a stay, whatever. So there's, nothing wrong with it in the abstract. What's different in this court, and what really came to a head during the year that I chronicle in the book, is the court started using the so-called shadow docket, not just for procedural purposes, but to actually make new law. And that's what the court did in this last term in some religion cases. They're not going to do it in the Mississippi case. Obviously, they've granted that case for review, and it's been fully briefed and it will be fully argued. So the public, in a way, the public's invited into that conversation. What's troubling is when the court makes law kind of in the middle of the night in cases that they have not formally granted. The public may not even be aware of the cases, and all of a sudden, we've got a ruling that kind of drops out of the sky at midnight. So, and the court has been using and I think misusing the shadow docket in that way, but that's not going to happen in the Mississippi case.
At least they may have a decision that will need modification and could do so under the cloak of the shadow docket. I suppose that's possible, but I'm just saying they're using this to get out of explaining themselves when they make inexplicable decisions. And that seems very tempting when it comes to abortion because it's such a controversial topic.
Well, where they were really using it in the last term, as I said, was in religion. So during the pandemic,
which is very which is so related to abortion.
So, during the pandemic, a lot of states, localities imposed various capacity limits on the number of people who could gather indoors for various reasons, including in houses of worship. And so churches began bringing, complaining about this, saying this violates our right to free exercise. You're discriminating against religion. You let people go to the mall, but you're only letting 60 people in my church. I really want to have 100 people, this kind of thing. And when Ruth Ginsburg was still alive and on the court rejected these cases by votes of 5-4 with Chief Justice Roberts and the then 4 liberals. Once Amy Barrett came on the court, almost immediately, Thanksgiving Eve of 2020, shadow docket case, the court flipped and by a vote of 5-4 overturned a New York regulation like this. And they kept doing that with these COVID cases, gradually sort of making, as I say, new law and, new power behind the free exercise clause of the First Amendment. And pretty amazing. I mean, it's a theme that really runs through my book, which is what they were doing with religion in the COVID context, in the LGBT context, and other contexts. And that's going to continue into the term that we're in now, for sure.
Thank you so much, Linda Greenhouse. Thank you for your book, Justice on the Brink. And thank you for your time talking about it. That's it for this edition of To the Contrary. Let's continue the conversation on Facebook, Instagram, Twitter, and our website, www.tothecontrary.org. And if you agree or think to the contrary, please join us next time.
Funding for To the Contrary provided by the E. Rhodes and Leona B. Carpenter Foundation, the Colcom Foundation, and the Charles A. Freoff Foundation. For a transcript or to see an online version of this episode of To the Contrary, please visit our PBS website at pbs.org/To the Contrary.
Be more. PBS.